You're gonna hold me here hostage until what? A body of a crime happens? When is the crime gonna happen?
Calling case number 25S00289. This is the State of Michigan versus Daniel Ryan Magoo. Can you please state your name for the record?
I'm trying to figure out what the charge is.
Yes, that is the purpose of the hearing today. So,
who's the complaining victim?
As part of the proceedings, can I have you please state your name for the record?
My name is Daniel Magoo,
Okay.
and I am not a surety of the state. I'm not a ward of the state.
Okay.
Can I ask what the charges are?
Yes, I am getting there. Please give me a moment. So what we are here for today is an arraignment. The purpose of an arraignment is to inform you what you are being charged with and to make sure that you understand the charges. I am not going to be asking if you agree with the charges. I am not even going to be asking if you understand why you are being charged with them. The purpose is to make sure that you understand what the charges mean and that you understand what the potential maximum penalties are. So, what I have here is a misdemeanor complaint that charges that on or about or between the dates of February 15th, 2025 and June 23rd, 2025, you did maliciously use a service provided by a telecommunications service provider with the intent to terrorize, frighten, intimidate, threaten, harass, molest, annoy, or disturb the peace and quiet of an individual with whom you have a child in common by using any vulgar, indecent, obscene, or offensive language, or suggesting any lewd or lascivious act in the course of a conversation or message through the use of a telecommunications service or device. This is otherwise known as malicious use of a telecommunications service. Do you understand what the charge means?
I do not understand that. I do not understand malicious use of a telephone service.
Do you comprehend that what I am saying is that you allegedly maliciously used a telecommunications service device that would generally be a cell phone? I suppose it could also be a computer or something else.
No, that didn't happen.
Okay. And
February,
again,
what were the dates? What dates?
Between February 15th and June 23rd.
Of this year?
This year. Yes. Okay. Now, as I stated at the beginning, I'm not asking you if you agree with the charges. I'm not asking you if you understand why you are being charged with them. What I want to know, basically, is do you know what the words coming out of my mouth mean?
No.
Okay. So the way that this is going to work is this. If I am not able to arraign you on the charges because I can't tell if you understand what I am saying, then the next thing that happens is that you get referred for a competency evaluation. At this point, I do not know how long that will take, and that means that you will stay where you are until we are able to either arraign you or you are determined to be incompetent.
So I don't have, I'm not, like I said before, I'm not a surety. Yeah. I'm not a ward. I'm actually a protected individual, and I did no crime. There has been no body of a crime, no corpus delicti. I have committed no crime at all.
Mr. Magoo. If I cannot determine whether or not you can understand what you're being charged with, then I cannot arraign you.
Okay.
So,
if there is not a body of a crime, if I have not harmed anybody, then you can't arraign me. It's corpus delicti. It can't happen. And if you do try to enter in a plea of competency, or I don't know what is that? What you're gonna hold me here hostage until what? A body of a crime happens? When is the crime gonna happen?
okay. So, Mr. Magoo, we will not be proceeding today with the arraignment. You are free to go to the door and tell the jail that you are finished. Thank you.
This hearing ends with a moment that perfectly captures how quickly courtroom arguments can collapse when someone focuses more on internet legal theories than on the actual process of the law. From the very beginning, Daniel McGoo tries to challenge the legitimacy of the case itself, repeating phrases like, "There's no body of a crime," and insisting he is not a ward of the state. But the judge keeps bringing the conversation back to a much simpler issue. This hearing is not about guilt or innocence. It's just an arraignment. The purpose is to make sure the defendant understands the charge and the possible penalties. That's it. The judge even explains carefully that he is not asking Daniel to agree with the accusation, only whether he understands the meaning of the words being read to him. What makes this exchange so important is that the defendant keeps confusing legal defenses with procedural requirements. He believes that by refusing to acknowledge the court's authority, or by invoking terms like corpus delicti, the case somehow cannot move forward. But criminal courts do not stop functioning because someone rejects the premise of the proceedings. In fact, the judge warns him that refusing to demonstrate basic understanding creates a completely different problem: competency. If the court cannot determine that a defendant understands the nature of the charges, then the law may require a competency evaluation before the case can continue. Ironically, the very strategy Daniel is using to avoid the process risks keeping him in custody longer. And that final moment is the key turning point. The judge realizes the arraignment cannot proceed because every direct explanation is being answered with sovereign citizen-style arguments instead of comprehension. So, rather than arguing back and forth, the judge simply ends the hearing and sends the matter toward the next legal step. It's a reminder that courts are built on procedure, not philosophy debates. A defendant absolutely has rights, including the right to challenge evidence and defend themselves, but those rights only work when someone participates within the framework of the legal system itself. Refusing to engage with that framework rarely stops a case. More often, it just delays the inevitable and makes the situation even more serious.